Welcome to the Future Media Podcast. I'm Ricky Sutton.
And I'm Alan Chappell. And this podcast goes deep into the collision of big tech
and the future of the world.
We explore how companies like Google, Meta, and Apple are impacting each of our lives.
I'm an investigative journalist.
I'm a privacy lawyer.
And every week we speak with experts to bring the unreported details into the light.
In mid-2024, Google tried to pull the sort of move that only an arrogant trillion-dollar company would ever have the minerals to dream up. It wrote a check to remove a jury. And this is how it happened. As the days counted down to its trial for being an ad tech monopoly, Google sent the US government a cashier's check for just over $2.3 million. Its lawyers had figured out that this was the most the Department of Justice could hope to win in damages, plus a bit more for good measure and a sprinkling of interest on top. Google's pitch to the court was simple. Look, Your Honor, we've paid every dollar owed, so there's nothing left for a jury to decide. So let's skip the theatrics and you can do the case yourself. And on paper, that looked really clever. Because juries are terrifying in antitrust. They don't tend to like big corporations or geeky billionaire CEOs. What they do like, though, is big numbers. And recent history is littered with eye-watering damages running into the hundreds of millions and beyond. Google's gamble was that the judge would take the money, dump the jury, and hear the case, and that would be calmer, more technical, and more manageable. But instead, it got something worse. Over 3 weeks in Virginia, Judge Leonie Brinkema proved herself to be an original gangster. She heard from 39 witnesses, tore through hundreds of exhibits, lambasted Google left, right, and center, and then issued a damning 115-page opinion. She found Google had monopolized key parts of the open web ad stack and illegally tied its ad server to its exchange, hiking prices and hurting consumers. Her verdict also delivered a detailed roadmap showing how Google built and abused its power in the pipes that fund online media and creators across the open web. Now, Judge Brinkema is currently making her final decision on what to do, whether to break up or constrain Google's $280 billion ad tech stranglehold. But even that, as big as that is, that's a sideshow to what we're talking about today. Because instead, we're going to rewind to that check because it's coming back to haunt the search giant. It's become ammunition in a separate coalition of publishers and advertisers who are suing Google for damages inflicted over that multi-million-dollar monopoly. And a judge in New York hearing the case has just ruled that Google's already lost that because it's already been litigated in Brinkema's antitrust trial. So thanks to that check, there's no jury ruling to appeal against. And that now multiplies the risk for Google after it tried to achieve that. So today, I'm very happy to say that we're joined by a lawyer who has an uncommonly expert view on all of this. Josh Haffenbrack was part of the DOJ's team that questioned and cross-examined witnesses over 10 weeks at Google's search antitrust trial. And he believes that this move with the jury has exposed Google to what he has described in a recent article as a devastating long-term risk. Josh, thanks for joining us. It's awesome to have you here.
Thanks for having me, guys.
So tell me, do you think Google made a mistake here? And maybe explain just the legal parts of what this meant.
Sure. And you know, it's easy to sort of see what Google was thinking strategically, as you sort of described in the lead up. And that is, juries have been pretty unforgiving for big companies and big tech companies in particular. And so, that they were facing the prospect of this jury trial and probably thought, with some validation in sort of past examples, past precedent, that they'd be better off with the bench trial than with the jury trial. It's easy to Monday morning quarterback and say it didn't work out for them because they both lost the bench trial, and then it sort of adversely affected their standing in the private MDL at the same time. And so maybe they would have been better off with the jury, but it's sort of hard to say that they made the wrong call in the moment, given the juries have been so so difficult for big companies, big tech companies in particular.
So, Josh, would you mind just taking a half step back and maybe explaining to the audience, most of which don't have a ton of legal background, what is issue preclusion? What is the mistake that Google may have made?
It's actually very unusual, maybe even unprecedented, for the DOJ antitrust division to seek a jury trial. And why is that? The reason is the DOJ antitrust division in civil cases is typically looking for what's called equitable relief rather than monetary damages. So they're looking for an injunction to stop a merger, to break up a monopoly. If you think back to sort of like the AT&T case, the remedy in that case wasn't damages or fines. It was rather breaking up the AT&T monopoly and creating all these localized television or telephone providers. So the DOJ in this case pursued a really interesting strategy of seeking a jury trial. And the reason that they could do that was the DOJ represents the United States government. The United States government does online advertising for various programs. You think about like the VA, the military, all these sort of aspects of the government advertise online. So they were claimed victims of the monopoly, that they paid too much because Google had a monopoly over the various advertising technologies that underpin the ads you see online. So they demanded a jury trial. They had $2 million in damages, and the parties were a couple of months out from trial in the summer of 2024. And Google said, aha, you know what we can do? The damages aren't a very big amount. What we care about more is whether our sort of business practices are broken up, whether our monopoly is affected. And so we'll cut a check for the damages, $2 million. And what that does is it moots out the damages claim, leaves only the injunctive relief left to be decided. And the injunctive relief is a matter for the court rather than a matter for the jury. So that's where Google was able to sort of narrow the case down to a bench trial. And then the follow-up question to that is why did that sort of implicate this collateral estoppel idea? I don't know if you want to ask me a separate question there.
No, keep going. You're doing great.
Okay. And so they go to the bench trial, and they lose after a 3-week trial. Dozens and dozens of witnesses. Judge Brinkema issues a very long, a very well-reasoned opinion. And at the same time, Google is facing these private lawsuits from class actions of companies that do business with their ad platforms. And after they're hit with this monopolization finding by Judge Brinkema, the private plaintiffs who are suing in New York, a different court in New York, say, wait a moment, the court in Virginia just decided the exact same issues that are pending in our case. It's the same conduct, the same monopolization, the same things we say are anti-competitive. The judge in Virginia has already decided. And so what the private plaintiffs did was that they made a motion for summary judgment, early summary judgment on part of the case. And summary judgment is basically a way to say that this issue is so clear or it's already been decided that it doesn't need to go to a jury in the first place. It can just be resolved right here by the court. And what the private plaintiffs said was Google already tried to defend itself on this monopolization point, and it lost. And it had a full and fair opportunity to litigate those issues, and Judge Brinkema in Virginia found against them. And so the same logic and the same legal holding should apply in our case. And the court in the Southern District of New York in Manhattan agreed with the private plaintiffs on that point. And this is where sort of the distinction between a jury trial and a bench trial comes into play in a big way. If you go to a jury trial, you've got a box there with 9 or 12 jurors. And at the end of the trial, the jurors just basically render a verdict of guilty or not guilty. There's typically a very truncated kind of verdict form. And in a case like this, an antitrust case, the verdict form might be as simple as, did Google violate Section 2 of the Sherman Act, which is the monopolization part of the Sherman Act, with no further details. And in that kind of circumstance, it's hard to tell what the jury was thinking. what they thought the relevant market was, which is an important point in an antitrust case. What sort of the line of commerce we're talking about? What conduct did they find anti-competitive? Did they find any of the conduct pro-competitive? So it's hard to sort of suss out the particulars of what the jury found when you've got sort of this general jury verdict that just gives you the top line answer, guilty or not guilty, liable or not liable. In contrast, when you have a bench trial in front of a judge, the judge will issue a very extensive opinion, but like Judge Brinkema did here, where they really outline chapter and verse the full reasoning behind their opinion. So Judge Brinkema detailed all of these points. What were the relevant markets? What were the key products at issue? She went through each sort of element of conduct by Google, the acquisitions, the various policies they have that affect advertisers, and explained whether and how she found them to be anti-competitive. So when the same issue popped up in the New York court, they could see very clearly, it was in vivid display in Judge Brinkema's decision, that she considered and decided all of these same issues that were at play in the New York case. And so it made it a lot easier for the judge to apply this doctrine that's called collateral estoppel and to say to Google, sorry, you've already litigated and you've already lost these issues. You can't get a second bite at the apple in our court.
Okay, I've just got one more question and then I'll let Ricky take over for a bit. But what happens if Brinkema's original decision gets overturned? Does that then have an impact on what's going on at SDNY?
If the decision was overturned, I think that the judgment of the court would have been reversed, the judgment of the Eastern District of Virginia, the district court, and there'd be no judgment against Google at that point. And for collateral estoppel to apply, you have to have a judgment against the defendant on issues that have been actually and fairly litigated in the prior litigation. So that would be a game changer if there was a reversal on appeal.
So. It put another way, this isn't really final yet until at least one other layer of appeals gets taken place. No,
that's true. The SDNY has issued its decision, and the parties will go forward with that. They're probably got years of litigation ahead of them still on issues like were the plaintiffs injured, were there damages, were there amount of damages. So there's still a lot left to be decided in the New York case. And as that's unfolding, to your point, if the Fourth Circuit reverses Judge Brinkema, that would reopen the issue of whether or not that they engaged in illegal monopolization to begin with.
All right. So as is commonly the case, I'm outnumbered heavily by lawyers on this podcast and people who know the details of the law far better than me. So I'm going to leave that to you. But I am interested in the people in making these decisions. It sounds like you've just described a double jeopardy for a tech company facing an antitrust trial. You can go to the jury, but juries don't like the idea of multi-billionaire tech barons. Yeah, they might be quite angry. That doesn't go down well with them. So you run that risk. Similarly, though, if you take it to a judge, you might lose some strength on your appeal. Do you think they made a good decision to do that? Or do you just think that it's a coin toss? What do you do?
It's a total coin toss. And let me give you another example. So you guys might be familiar that there's been a couple of cases out in California brought up by Epic, which is a game maker.
Yeah.
And they sued both Google and Apple over their App Store policies. And this is a really interesting natural experiment for what you were just talking about, because Epic's case against Apple went to a bench trial, and Apple won on the federal antitrust claims. So they win with the judge. And then shortly thereafter, in a parallel case, the same exact plaintiff in the same exact court went to a jury trial against Google, Epic versus Google, in front of a jury trial, and Google lost in front of the jury. And so you see this sort of natural experiment, and I'm sure this was something Google itself was aware of, having just done it in the Epic trial, or it was going through it at the time in the Epic trial. That you've got a pretty clear example of a big tech company faring better with the judge than with the jury. So it's hard to say they would have done a lot better in EDVA if they'd had a jury instead of a judge.
I'm so glad you raised that. Alan and I both followed that Epic case very, very closely, The jury took 2 hours and 38 minutes to come back with their decision, which included an hour for lunch.
I mean, I think it proves out your point to a degree that the jurors, you see in public surveys that, they don't have a high opinion of big companies or big tech companies. And I think it's tough sledding for a lot of them in front of a jury.
Can I just ask? I remember seeing that check. I saw it in the court papers and being just stunned that was even something you were allowed to do. I was surprised that was an option that could be effectively bought. What are your thoughts on that? It feels like, to the average layman, the thought would be, well, the judge decides this, right? You can't buy it in or buy it out. That feels strange.
Yeah. They were able to buy their way out of having a jury because juries can only determine damages claims, that they can't determine injunctive relief. And when all that's left is like, well, what are we going to do with the monopoly? What's the solution going to be? What's the remedy? You're leaving only sort of the jury question, or I'm sorry, the court question. It is a bit unusual, and it's unusual because if a defendant is willing to pay every penny of the plaintiff's damages, it usually just settles the case.
Yes.
And there's usually nothing left to fight about because most cases are about damages. And the one context I'll mention where you see this quite a bit is in like class actions or collective actions, often in the labor context, where defendants will try to sort of, they call it picking off, that they'll try to pick off a named plaintiff by paying all of that plaintiff's damages. And then there's no one left to represent the class, and they try to moot out the claim. So it can seem a little lawyerly and a little tricky, but it's not unheard of for defendants to come in and sort of strategically to pay all of a damages amount, particularly if it's a low number. $2 million is a drop in the bucket for Google. If they see some strategic advantage in it, even if it's marginal strategic advantage, they're much more interested in being able to run their business how they want than they are in the sort of low amount of damages figure that was at issue here.
It feels like part of the strategy for Google here is to create as many different side deals and side dramas as they can. I mean, like right now you've got a number of class action cases, but there's one that is about to settle and they've got some of the terms ready. I guess it gets approved or not in January, but one that enables the creation of an RTB control, something that zaps a good portion of the RTB string from the ad space, which is kind of weird because Google may not own the ad exchange by the time that settlement gets imposed. And then you've got final arguments last week where Judge Brinkema made very clear that part of her thinking about what is a good remedy in this case is driven by the timing of some of these private lawsuits. And so it's funny, I go back and forth thinking like this was a really huge blunder by Google. And then the part of me wonders if maybe this was kind of brilliant because you've just got so many things cooking on so many different levels. And they've got the budget for, thousands and thousands of lawyers and policy people to try to think through all of this stuff. But everybody else is sort of left flailing.
I mean, and if they get in the end a remedy that they can live with from Judge Brinkema, that they may think this has been a fairly success, even though they were found for the second time liable for monopolization. If, for example, they don't have to spin off AdX, their advertising exchange, and the remedies are seen as a little watered down or not as strong as they could have been, Google may think that this wasn't a mistake at all. We got off without having to fundamentally sort of change our business, and that's a big, if that's the case, that'll be a big victory for them.
Yeah, I think from their perspective, it's really about the private litigation and how much financially that's going to end up costing them. And right now that's sort of I think the biggest risk, because it just doesn't feel like the search case isn't going anywhere. That's just going to be an exercise in fighting over behavioral remedies. And Google is brilliant at those.
And when you're talking about a company with the degree of profits that Google has, 100 billion plus every year, a private damages suit has to be an astronomically large number to feel like anything more than a mosquito bite to them.
Yeah, Alan and I have spoken a lot. I think we've had some of the principals on this podcast that are involved in these class actions. We have class actions in Canada. I think are currently sitting at about $6 billion in claim damages. I think we've got 8 billion in the UK. We've got about 10 billion in Australia. These are ever increasing numbers of publishers who are seeking damages for things that go back, I think 8 years is the limitation here. It looks like there are going to be a series of settlements. There's going to be a lot of money spent. This is going to go in and out of court for a couple of years, and Google's going to pay. But it feels to me like Google's much more focused on, okay, we're going to have to do that. That's kind of a sunk cost. We've accepted that there's going to be some element of this that's going to happen. But what we really, really don't want is we don't want the wheels on our cars to be taken off, right? We still want to be able to keep going on the path we're on. We want to have the optionality to choose where we go next. Do you think that was part of their thinking? Or I think I'm hearing you say you think that was part of their thinking. It's just to rip the Band-Aid off this problem and just get on with business as usual.
I agree with you. I mean, I have no sort of insight into Google's internal thinking on this, but my sense is the same as yours, that they care a lot more about sort of their ability to run their business the way they want than they do about sort of one-time damages fees that they might have to pay that amount to, even all those numbers that you just mentioned. They're big numbers, but you add them all together, it's a couple of months of profit for Google.
What was the reaction at the DOJ when you heard that they were doing this? What did somebody kind of like go shout across the office and drop their coffee? How did it go down when you heard about it?
So I was two things. I was already back in private practice. So I did the first. I was part of the trial team on the first Google case, which was about their flagship search product. This was the second case against Google in the queue, prosecuted by a separate team of DOJ attorneys. And it was as a year or so after the search case. And I was back in private practice. So I'm not sure what the reaction was when they found out that their jury trial was no longer going to be a jury trial.
So where do you think this leaves us now? I know that you to your point, you weren't involved in that final trial. My shorthand of this is that there was a trial. It was the Epic trial. No one talks about that one. Everybody seems to have put that one away in the corner. It was in front of a trial. Google lost, was found to have monopolized the App Store. It went to appeal. The appeal was lost in just over a year, 13, 14 months or so. And now major structural changes are underway all over the world with the App Store, which means the fees have come down from 30% to some. I think they're currently negotiating somewhere between 7 and 13 or something. So the objective was achieved. Structural change and behavioral change occurred. Okay. Then in the second case, we had a trial. This was the search trial. We had a trial. Google lost the trial. But the remedies felt like a slap on the wrist. That's the way it's described by everybody. Everybody talks about a slap on the wrist. It didn't really feel like anything actually changed really in that. It was just business as usual. Please, let's forget about what happened. This one feels, to use a good English sporting analogy, it's 1-1 and we're going into extra time. Okay. Who's going to win, right? There's a deciding goal is coming. Do you think that's how it's being viewed by the DOJ, having worked there? Do you think that's a fair description of what's going on, or is it much more nuanced than that?
In terms of the ad tech remedy you're talking about?
Well, I'm just saying that trying to rein in big tech, the mission here was to rein in big tech. We've got 3 legs of a stool here, right? App stores, search, and ad tech, right? We've got one win that kind of looks like a loss, and then we've got this last one. Do we have to wait for this final decision to figure out whether the DOJ succeeded or not here?
I mean, the DOJ won both cases. we got some the judge in the search case. He didn't go as far as the DOJ wanted. He did impose some remedies that will result in sort of data sharing and could help prop up competitors and open up the market to a greater degree of competition. So I think we'll have to wait and see a little bit to see how effective that remedy is. I think one of the stories here is that antitrust is often just a tough tool to try to rework a market like this that's changing a lot. And you see, in the Google search case that there was sort of AI. Really, I mean, AI was barely mentioned in discovery or even at the trial in the Google
I have
search case.
reported on exactly this. I counted the number of times it was mentioned in the complaint, and then in the decision and the ruling, and then in the remedies. And it was 2, 16, lots and lots and lots.
And this was 10 weeks of trial with 40 some witnesses. AI was, it was mentioned a few times, not a big focus. And then it was basically the overriding concern, the overriding factor animating Judge Mehta's decision on the remedy. And then another example I point to is the recent Meta case, the FTC Meta case. When the FTC brought that complaint, didn't mention TikTok once. TikTok barely even existed. But by the time the decision is issued a handful of years later, TikTok is the main reason that the FTC lost that case, because it just wasn't, the judge didn't find it plausible, didn't find the evidence supported that TikTok doesn't compete in the same market with Instagram and Facebook. So, in these, when you've got an antitrust case, you think about how the DOJ operates. Often takes several years to investigate a case and file a complaint, several more years to litigate it to trial. It can take another year for the judge to issue its decision, another year for the remedies phase and a remedies decision. And you're talking about 5, 6, 7 years of a litigation time span in industries that change a lot.
I was asked about this just yesterday here in Australia. And my response was, the tech companies move fast and break things, and courts move slowly to fix things. And these two things are colliding. Yeah. And I read that Meta ruling, the sands literally shifted under the feet of the FTC from the time it brought the case to the time the case was litigated, which meant that the whole world looked different. Google used some of that argument in its court cases as well. Sorry, Alan, I didn't mean to interrupt you.
No, I think I'm making a similar point, although from a slightly different place. I mean, we now have 50 years where judges have been sort of indoctrinated into some flavor of the Chicago school. And at the end of the day, they are going to err on the side of caution to protect the marketplace. And as a result of that, 9 times out of 10, or maybe 99 times out of 100, that means protecting the monopolist. And so as a result, given, I think what Josh rightly said in terms of speed, you've got some of the cultural issues just of how it's been implemented for the last 50 years. It just doesn't feel like antitrust is going to be the tool that's ultimately going to fix the marketplace. Unfortunately, that means we got to turn to Congress, and then that has its own challenges and logistical issues.
Well, they've been pushing that boulder up the hill for years and haven't been able to get anything through. And Amy Klobuchar and others. And I agree with you, Alan, that there is a deep-seated institutional reluctance, I would say, to implement really aggressive remedies that fundamentally sort of disrupt a market. And even if you look back at the Microsoft case, the remedies there were sort of halfway to what the DOJ wanted, and now they're the remedies that were implemented are credited with doing a lot of good in those markets. But even that opinion wasn't, you look at the DC Circuit opinion, wasn't breaking up the company in the way that the courts have done many decades ago. It's just not something that's in the DNA anymore. And I agree with you that a lot of that is around sort of where antitrust law is headed since the 80s and since the Chicago School and Judge Posner and others really changed the way that courts and litigators too to think about these issues.
So I'm 20 plus years in waiting for Congress to put out a federal privacy law here in the U.S. And so we could have an entire podcast episode on that alone. But let me ask you a question. One thing that I don't understand about the DOJ's strategy. Google was there was a whole bunch of evidence that Google had spoiled evidence. There was just a whole bunch of things that got right at the heart of whether Google was going to be trustworthy. And a lot of that was uncovered during each of the trials, the search trial and the ad tech trial, but barely a word uttered about those things as you headed into the remedies trial. And I wonder why the DOJ didn't jump up and down and really harp on that point, given that so much of this remedies, in order for them to work, sort of assumes that Google is going to be trustworthy in how they implement the remedies.
I would, Alan, disagree with the premise of your question. We did jump up and down. The DOJ in both cases, filed spoliation motions, aggressively pursued. You can just look at the public record and see that we developed. The DOJ developed a record that Google. What they'd done was that they had these chat functions that were set to automatically delete. And what you're supposed to do as a litigant, when you're sued or when you're facing litigation, is you're supposed to suspend all sort of auto deletion functions, and you're supposed to preserve your messages. Google didn't do that, and it allowed all these messages where people were communicating in a candid way with each other about the policies that were at issue to be deleted every day. We put. I think that the DOJ pressed this issue to both Judge Mehta and Judge Brinkema. Alan, one thing I'd point out is the DOJ won both cases. And I think the judges were just being, they didn't need to reach the spoliation issue. And judges often, if they don't, it's kind of the reluctance to do sort of an advisory opinion or reach a question that's not necessary to decide the case. If you're going to find that Google's liable for monopolization anyway, that there's kind of, in a sense, no need to reach this question of whether they spoliated evidence, and that spoliated evidence would have allowed us to prove illegal conduct, because we proved illegal conduct on the basis of the evidence that we did have.
So let me push back on that just a little bit.
Sure.
Really, because you were there and I was not. My issue is not what transpired during the first trial. My issue was that what transpired during the remedies trial, and you may not have been there for at least part of the remedies trial. But if you look at the final proposal of remedies from the DOJ, nary a mention of the evidence spoliation. And I'm just wondering if it sounds to, I'm inferring maybe from your answer that it's like it's not necessary because we've already proven that.
So I was not there for that remedies portion of the search trial, so I'm not sure, and I couldn't tell you anyway, even if I knew, and I don't know what went into the DOJ's thinking on whether or not to seek sort of includes the spoliation as part of the remedy. But I will tell you, Alan, just sort of speaking as a general legal matter, the Judge Mehta had already found that he didn't need to reach the spoliation issue, so there wasn't a finding of spoliation. And typically, if you want to get a remedy for something, you would typically need a sort of a foundation for that, a finding that they'd done something unlawful in the first place. And Judge Mehta didn't find that; he just didn't reach the issue. And it's kind of a side. It's kind of the case. The DOJ didn't sue Google because of its document retention policies. It sued Google because it had an unlawful monopoly over search. And so I think this is just as an outside observer. For this phase of the case, that the DOJ was rightly focused on remedying the things that animated the lawsuit in the first place, the things that were actually harming consumers and competition, which were the search monopoly, not the document maintenance practices.
Fair enough. I guess my only retort, and I say this as someone who is not a litigator, but my only retort would be that judges are humans, and making sure that evidence regarding Google's trustworthiness, it would be helpful to have that more upfront.
Yep. I hear you.
I might jump in just on that. So this was something that really leapt out at me, this evidence spoliation thing. Even somebody that doesn't work in law, I know what an evidence hold means. I'm pretty clear that there's a logic that if you're being tried for something, you need to maintain the evidence that exists, and you shouldn't be getting rid of it. And I think you were fairly kind in the way you just described the way that Google handled that, because they actually trained their staff. It was in the evidence that they sat down and trained their staff and said, it's up to you if you use email or you use this chat situation, it's up to you. But if you use email, it may very well be evidence. We'll just leave it there. Yeah. And so I think, there's kind of a core of human judgment that would basically say, well, that feels a bit odd. And I believe, unless I'm completely mistaken, there's actually a trial going ahead on this. There's a series of states have brought a case for this. But what really amazed me about that was I was, and Alan knows this, I was in Cuba making a documentary for Netflix. Okay. And literally I'm walking down the street in Cuba and my phone rings and it says, the judge in the App Store case, James Donato, is going thermonuclear, was the word I heard. He's going thermonuclear about this evidence being taken away. And he said words to the effect, I won't have this verbatim, but it's very close. He said, this is an affront on American justice, and it's not going to be dealt with in this court, but I will do it myself outside this court to ensure that there's an investigation to make sure that this is checked and dealt with. And then it went obviously to the second trial, and Judge Mehta referred to it and said, this is a problem and it's going to be dealt with. And then it went to Brinkema's trial, and she said, this is a massive problem and we're going to deal with it. And now we have this separate case. This might be outside your jurisdiction or thoughts, but where do you think that trial goes? Because that feels like a ticking time bomb, because that's the kind of trial that gets under the skin of the public. Yeah. It's not technical. It's not competition. It's just wrong in the public's mind.
Yeah, and I'm not sure the particulars of that case. I know the evidence spoliation. I mean, it was initially developed by the Epic lawyers in the Google case out in California. And you're right that Judge Donato was very displeased about Google's practices.
That's such a lawyer. That's a lawyerly phrase. I used thermonuclear. You used displeased. We're clearly in different trends.
He held a hearing about it. He was suffering no fools on the issue of the evidence destruction. And I know it's been asserted by other private plaintiffs, and I think it's going to continue to be a problem for Google that plaintiffs are going to say, look, there might have been all this great evidence that Google allowed to be destroyed, intentionally allowed to be destroyed. So, I think it's going to continue to bedevil them. I don't know, this specific case, I'm not familiar with the details, so can't really comment on that one.
One of your colleagues from the DOJ got up at the start of the search trial, I believe, and it might have been you, in his opening statement said something like, there's no smoking gun in this case because Google ensured there wouldn't be one. Yeah, so he
might have been my colleague Ken Dinser, who was a great trial attorney, and he was the lead attorney at the search trial.
It was. I remember listening to that and just thinking, this is going to be an interesting trial. I'm looking forward to this. So we are at the end of, how long has this all been going on? I mean, how many years is it? 5, 6?
Which one?
Or just this? Well, I suppose if you go back to Epic all the way to where we are now, best part of 5 or 6 years or so, would you say?
Easily. So the search case, the DOJ filed the complaint in October 2020. Ad tech case was a little later, but it went a lot quicker because you may be familiar with this, but the Eastern District of Virginia is known as the Rocket Docket. Yeah. Because it hurdles cases so quickly through. So where the Google search case took 5 years to get to a remedy, the ad tech case was quicker. Both investigations started before that. So you're looking at 5, 6, 7 years for its sort of total lifespan just for the Google cases. And then there's a bunch of other cases. there's cases against Apple, against Amazon, against Visa that are all in the pipeline that'll play out over a number of years. The Meta case was 5, 6 years.
There were several of Alan and my friends and a couple of people we've had on this podcast were witnesses in some of those cases in the Rocket Docket, and would be called up in the morning and just go, how many witnesses you got? No, yes, no, yes, no, next. It was like, okay, this is going to go quick. So we're almost at the end. So I think that Judge Brinkema had alluded to the fact that she'd come back with a decision before the end of the year, but she's now extended that into Q1 next year. I think there's a lot going on behind the scenes. I suspect that there's an awful lot going on behind the scenes. But we're nearly at the end of this. As somebody that spent a lot of time on this trial, how do you feel about it and where it's gotten up to? That's kind of my last question. How are you feeling about the whole process and where we've gotten to? Because it really has, to your point earlier, pushed the absolute boundaries of competition law. It really has pushed incredibly hard.
And I will say, if you take a step back, there was a 20-year gap with basically no monopolization enforcement in the United States. There was the Microsoft case and then virtually nothing until this recent spate of cases. And I think, this I think is to the credit of the first Trump administration and the Biden administration of really sort of revitalizing the Section 2 doctrine, bringing these cases. Some of them are hard cases. They're all cases that are, with well-funded defendants that have armies of the best lawyers in the country, but very talented lawyers on the defense side. I really do think that it has, as you put it, pushed the boundaries of Section 2 law, but breathed new life back into sort of these sort of monopolization type theories. And there's more in the pipeline. That I think the Amazon, the Apple, and the Visa cases all could be very significant cases as well. That you might have seen that the DOJ just settled the case against RealPage, which was a really interesting case about algorithmic price fixing in the real estate rental market. It's easy to sort of narrow in on the remedies and second guess or criticize judges that didn't go far enough in the minds of some. But I think if you step back, the last 5 and 6 years have been, if you're someone who believes in antitrust enforcement and believes that there's been too much corporate concentration in the country, it's been a remarkable period of activity and sort of breathing new life into these enforcement type of cases.
Amazing stuff. Well, I can tell you that is borne out. I am a personal proof point of that, because as an investigative journalist, I never thought I'd be interested in a 120-year-old law that I wanted to. And I've been back and I've read, and it's taught me all about the Gilded Age, and it's taught me all about the robber barons, and it's taught me all about
absolutely
the Depression, and it's taught me about the geopolitics of the time and wealth disparity, and it's created an entire 3 years of a brain expansion for me, leading to these.
I love it. So some of the old John D. Rockefeller books are really interesting, and the Sherman Act really is the charter of economic freedom in the United States.
Sorry, I said it was my last question. Here is my last question, because it came up again yesterday in my meetings here. Europe and some other jurisdictions have taken a different path. Instead of litigating on a case-by-case basis, they've kind of passed Extant, I think it's called Extant law, is it? You please fill the gap, where basically they designate these organizations as gatekeepers, which is kind of an assumption that they're a monopoly up front. And then they deal with the behaviors, not necessarily with proving it's a monopoly first.
The DMA.
Yes,
the Digital Markets Act.
Absolutely, yeah. So it's kind of put down a marker that says we know that these are monopolies, and we're going to deal with it with that assumption. Now, the UK's doing something similar. Europe's doing something similar. Australia's talking about something similar here. It came up here yesterday. Is that something you think the US needs to stop the FTC having the issue it had with Meta? Is that something, or is it even achievable in the political maelstrom that you kind of have?
It seems like a much narrower version of that bill that Amy Klobuchar and others spent years trying to push. Didn't get enough traction to get through Congress. I think there's a lot of sort of lobbying opposition to that kind of stuff. And I think some of her bill was sort of more modest and focused around trying to smooth out the edges of some of the technicalities in antitrust law that defendants can often exploit to defeat a case, even if substantively what they're doing is anti-competitive. So it might be, over time, some version of that kind of bill could come into law. I don't, in terms of like a congressional prognosticator, that you could find a lot better pundits than me. But it just doesn't seem something that's really in keeping. If you look at Europe, it really hasn't had the innovation the United States has had. All these big tech companies are American based, and all of a lot of the AI innovations in America is not in Europe. And I think some of these companies could make a valid point that you don't want sort of overbearing regulation that's going to prevent the kind of innovation that you've seen in the United States and not in Europe. And maybe some of that is attributable to to the regulatory differences in those two countries.
Well, heck,
but this is beyond my. I'm just a lawyer and a litigator. These are sort of policy questions that are above my pay grade.
yeah, I mean, the EU right now, if anything, seems to be heading much more towards a laissez-faire, rethink of their whole regulatory environment. And then the challenge with just politically trying to bring something like, hey, Mr. Senator, we want you to sign off on this bill that's really like what they do in Europe, and like just as a matter of policy, that's just going to turn them off.
Right.
Well, let's leave it there. We'll solve world politics and world law next week, but that's been absolutely terrific. Josh, thanks so much for coming on. I really appreciate it. Your insights have been amazing. The law constantly thrills me now. I've never had so much fun diving into it. So thank you for you and all of your work.
I'm glad to hear you're a convert to antitrust law. I agree. It's a very interesting little corner of the world, and has been especially so in the last few years. And I thank you both for having me on. It's been a blast.
Thanks for coming on, Josh. This was great.
Thanks for tuning in. The Future Media Podcast is a production of Future Media and Ricky Sutton.